After 20 years, finally the Social Security Administration has instituted bias procedures. Hi, I'm Mark Whitehead, a board-certified disability attorney and author of the Disability Help Book, The Social Security Disability Puzzle, How to Fit the Pieces Together and Win Your Claim. Way back in 1992, after years of disability lawyers complaining about judges who showed bias against people applying for disability benefits, the Social Security Administration released what they called a notice. This notice described the procedure that they would be using to handle these types of complaints. However, the procedure in the notice was considered interim rather than final, which basically meant it couldn't actually be used in practice. No big deal, right? This is the way the Social Security Administration works with new rules. They publish a rough draft, work out the kinks, then release the final version so that it can be used in real cases. But here's the problem. No final rules were ever published. For the last 20 years, claimants and representatives have been able to point to the interim procedures as proof that the Social Security Administration knew that there was a problem with biased judges. But they still couldn't do anything about it unless they wanted to file a class action lawsuit against the Social Security Administration itself. Well, earlier this year it finally happened. Those final procedures were actually published, and now there's a way to actually deal with the bias using the Social Security Administration guidelines. This should be a reason to rejoice, and obviously it's good for claimants. But why did it take 20 years? Why publish these official procedures now? It comes back to the bias settlement I mentioned last week. Why did it take 20 years to finish the procedures? Quite simply, because the Social Security Administration knew they could get away with bias as long as there weren't any specific official procedures in place to deal with it. That may sound pessimistic, but try to come up with another rational reason explaining not only why it took so long, but also how the agency was able to publish their final procedures so quickly after being forced to do it in a settlement in a 2011 lawsuit. There are only two answers that make sense, and neither paints the Social Security Administration in a favorable light. One is that they've had the procedures ready for a while, but simply decided to sit on them. The other answer is that they've been sitting on their thumbs for over 20 years, but were so scared of the settlement that they rushed the final procedures through after they knew they were going to lose. What's so disappointing about this is that the Social Security Administration is supposed to be looking out for the people who need help, not working overtime to keep them from getting benefits. Situations like these are why it's so important to have a good Social Security attorney on your side. If you have more Social Security questions, check out my free ebook, The Social Security Disability Puzzle, How to Fit the Pieces Together and Win Your Claim. Visit www.disabilitydenials.com for a free downloadable copy, or call 1-800-562-9830 to discuss your particular disability issue. I'm Mark Whitehead. Thanks for watching.